debt collectors are suing people left and right. And we have here LVNV Funding LLC, and this is a public case. So, I have the person's name here, but this is public documents. So it is available to the general public. This case here is a very good one because she is actually fighting against LVNV Funding, which is a debt collection company who buys old credit card debt and they go after people to sue them. And the reason why LVNV Funding has made millions of dollars and probably getting close to billions of dollars is because most people do not know their rights when challenging and responding to these debt collection lawsuits. And it's been shown that over 95% of the people end up getting a default judgment. That's where they don't show up to court. And then the other 4% do not know what they need to say to respond if they do decide to respond to the summons or complaint from LVNV Funding or debt collector who has purchased their debt and trying to sue them. And then less than 1% actually know what to actually challenge and how to challenge it. And they end up losing their cases because of that. So you can see that there's a huge incentive for these debt collection companies to buy the debt, which they do buy for pennies on the dollar. But when they take people to court, they are spending real money. So if you're looking at taking, let's just say, 1,000 people to court in my area, that debt collection company would potentially have to pay almost $100,000. But you can see that they can make a lot of that money back quickly by winning default judgments. Now, because companies like mine and people are getting educated on their rights, we are starting to see debt collection companies, they're not giving up and dismissing the cases based off the responses. Because the way that she responded in this, some debt collection companies would walk away. And I'll just kind of show you here. She answered in her response to the summons, is she just basically said that she denied owing the debt and had no business relationship with the plaintiff and asserted that the plaintiff lacked standing, which is what you will see on YouTube, what you will see, on ebooks and some of the websites that tell people how to respond. That is one of the responses. I would tell you that that is not good enough. It may have worked in the past, but it is not good enough right now because these companies have spent millions of dollars buying debt and they want to make their money back plus profit for themselves and their investors. So what they've started doing is they would motion for summary judgment. Now, if you get with the right judge and your area is not, against consumers, in my opinion, they will not allow the summary judgment motion to go through because the only reason why they would be able to do that summary judgment is if it was something that was not going to be able to have a case. There is a remedy for this court case. So LVNV Funding was trying to get a motion for summary judgment because they're saying that, with the information that they presented and with the response from this individual, that they have enough information to move for summary judgment. And the judge said no to that. So here you go right here. I'm going to kind of skim through this. So let's first look at this. Plaintiff's motion for summary judgment is denied. Plaintiff filed this action against defendant seeking $1,193.52 for an alleged, and remember that, alleged credit card debt originally owed to Credit One Bank. The debt was originally sold and transferred several times until ultimately being purchased by the plaintiff. This is very important. Remember this. We're going to get into the problems with that in a minute. The complainant lists two causes of action: breach of contract, which they always put in there, and an account stated, this is the requirements under the Fair Debt Collection Practices Act. If people don't do anything, they're going to get away with just putting those in there. Now, the defendant stated that she denied owing the debt, denied having any business relationship with the plaintiff, and asserted that the plaintiff lacked standing to sue. So the plaintiff now moves for summary judgment solely on the second cause of action, and of which was the account stated. The motion is denied as plaintiff has not established that the actual that it actually acquired the alleged debt, and that it therefore has standing to sue the plaintiff. So, see, this is very important. They have to prove the alleged debt, how they got it, how they acquired it, all of that stuff. And there's a whole bunch of problems with this one specifically because it passed through several hands. So now, this here shows what the judge stated, that if there's no remedy. So look, judgment is a drastic remedy that should not be granted where there exists a trialable, forgive me for that, issue of fact. So basically, in layman's terms, they could actually have the judge rule on the information that is being presented. And you can see here where they had stated right here these different cases where, hey, we need to go to court on this, not where you're just going to file some documents and the judge is just going to go ahead and just give you a summary judgment on this. So let's move forward. The proponent of the summary judgment motion makes a prima facie showing by tendering sufficient evidence to eliminate any material issue of fact from the case. And then they stated this case here. Once the moving party has demonstrated its prima facie showing, the burden then shifts to the non-moving party to demonstrate by admissible evidence the existence of a triable issue of fact necessitating the trial. So let's just break this down, and I've talked about this a lot. So basically what they're doing is they're shifting the burden of proof to the defendant. The way that they're able to do that is by the defendant saying that I have no business with you. You have not proven, that you own the debt. Like that's basically, what it basically comes down to. But let me tell you the problem that I see happen time and time again when the defendant sets up their affirmative defense just based on those few things, is that they will file for a motion for summary judgment, and then if you do not have equip yourself with a response that's going to be more than it's just not mine and I have no business with them, the judge is going to more than likely allow that to continue because the burden has been changed over into your hands of proving your side more than them proving their case. And it states it right here. It states it right here. So you can read that for yourself and you can see your state laws. So basically what you have to do is you have to break apart the documentation that they've submitted, and that will allow you to, number one, back them into a corner to where they're going to say, if this goes to trial, we're not going to be able to overcome this. Because what they want you to do is they want you to get to start to stating other cases, and there's nothing wrong with that if you're educating yourself to do that, but you got to be prepared that it's going to be back and forth, because if they can find a case, if you can find a case, they're going to find a case. But the bottom line is the documents that they submit for their allegations is ultimately going to be what the judge is going to decide on. And so you need to look at the documents that they presented. So you look at the allegations and then you look at the documents that they presented. So now let's look at this here. In this matter, what they did is they submitted documents. And I've made videos showing this before, but let's look at this chain of custody. And I'm going to break down the problems that I would see in this chain of custody. So, number one, Credit One Bank sold and assigned defendant the debt, which is MHC receivables. MHC receivables is a debt portfolio company who buys debt and then they will sell it. First, they'll usually try to sell it to their own collection company. So you can see here that the MHC sold and assigned the debt to FNBM LLC. And then FNBM sold and assigned the debt to Sherman Originator 3 LLC. And then Sherman Originator 3 sold it to Sherman Originator LLC. And then Sherman Originator LLC sold the debt to the plaintiff, LVNV Funding. Now, let's just break down the problems with this. How is LVNV Funding going to state that they have any connection with Credit One Bank? Any connection with Credit One Bank? The way that they're going to try to establish that is they're going to say that they got the documentation. They may just outright say that they got the documentation for Credit One Bank, but that would not be true in their summons. So they've already, by stating that they got the information from Credit One Bank, that would be one of the ways that you would break down using their own documentation, rather than saying that you have no relationship with them, which you should state that in there, but you should also state because the plaintiff did not get the debt from the original creditor. Now, before moving forward to the other ones that purchased the debt, when you review that sale contract that should be attached with MHC, look on there to see if Credit One Bank, which Credit One Bank is notorious for saying that when they sell debt, that the debt collection company or portfolio company cannot resell that debt to anyone. That MHC would be required to collect that debt. So that's going to be one of the things. And then you would put that in your affirmative defense. The next thing that you would put in your affirmative defense, and you've already included that you have no relationship with them, is that you want to ask them about where is the extension of giving access to your information, your private information from Credit One Bank. So did Credit One Bank give it to MHC, and then MHC gave your personal information to FNBM LLC? How can they give your private information to this debt collector? Did you sign to have that given over? So when they took over this contract here, and I'm pretty sure that she had some sort of privacy agreement with Credit One Bank, that privacy agreement needs to be reviewed to see if that would be able to extend to MHC receivables. And then does that linkage allow your private data to be transferred without your permission to FNBM LLC? And then again, would that allow that your private information to be submitted to Sherman Originator 3 LLC? And then could they again do that to Sherman Originator LLC? And then could Sherman Originator do that with LVNV Funding? So you have your private information being transferred from 1 to 2 to 3 to 4 to 5 to the plaintiff LVNV Funding 6 times, and probably only one time the permission would be granted. Now, the next issue would be the amount owed, the claimed amount, which is something that a lot of people do not pay attention to. If we look up here, they stated that they had a claimed amount of $1,193.52. So now, Credit One sold the account to MHC. We want to see the documentation more than just a couple of statements showing how that amount was accumulated. And then once MHC sold that debt to FNBM LLC, and then Sherman Originator 3 and then Sherman Originator LLC to LVNV, isn't the plaintiff actually only getting information from Sherman Originator LLC? So LVNV funding, when it comes to that debt, would not even be able to reach out to the original creditor to see how that debt of $1,193.52 was even accumulated. They don't want you to ask that question. The next thing that we would want to know is, did MHC, FNBM LLC, Sherman Originator 3, and this is a different one, Sherman Originator LLC, did any of these companies file a 1099-C, cancellation of debt, to get a write-off? Because these companies are not just selling this debt. If they bought it for pennies on the dollar, do you think that this company here is going to buy that debt for anything more than pennies on the dollar? So there has to be some sort of incentive for this to be able to go through these hands. Now, the number one reason why is because a lot of these companies are not debt collection companies. What they are, they're portfolio companies, and they're trying to pad the responsibility of any issues that may come up with LVNV. If these companies would be protected because they've sold it, and each of these are their own individual LLCs. So we would want to know, how did they come up with that claim dollar amount? We would want to know the privacy given the privacy permission to view your private information from each of these companies. And then we would want to know the accounting. How did this company say that they got to this number here? How did this company say that they got to that number? How did this company say that they got to that number? And how did this company say that they got to that number? LVNV funding cannot state that they had any communication with Credit One. So you're going to be looking at the summons to see, to poke your holes in their summons. And if they turn that around on you and they do that motion to where the burden is placed on you, you would still be able to use that information based off of their documents. So you would just turn it around and say, okay, I want to know from the documents that you've presented to the court, how did you come up with this information? When you did purchase a debt from Sherman Originator, show me the documentation of that contract from Sherman Originator. Because what I've seen happen is that all of this here is really done in one document transaction, but we want to know if it was done individually. Because this is what they try to do to get people confused, to show that this chain of custody with all of these documents, that it was just something that was done from here to the plaintiff, when it was not just done from there to the plaintiff. So you have a right to see how all of those documents were transferred with your private information, to make sure that that was done right, to make sure that that claimed amount is correct, to make sure that the full account number is correct. And that is how you would beat a motion for summary judgment. So when they submit that summary judgment, just to review, you always have a right, because this is something that that a trial could be set up for. They will try to do a motion for summary judgment based off of the documents that they presented in a way, hoping that you don't respond, and they're just trying to get it based off of the documents that they've submitted. And it mostly happens when an affirmative defense is not based off of the documents that they've presented. So you always want to make sure you do that, and you do have a right. So don't get scared if they motion for a summary judgment. And the next thing is you're going to want to, number one, make sure that you challenge and see the documents for yourself, the privacy, for them to be able to view your private information. And that's going to be for every collection company that was in that chain. You want to know, here, this is how we do it. For everything that you would ask LVMV funding, you're going to put in your affirmative defense to make sure that every company also had that information, and that you want to have proof of how that information was transferred from company to company. And then when it comes down to proving the claim, you will want to ask directly, how did they review that claim if they had no direct relationship? That claimed amount, let me be clear, the claimed amount, how did they get that claimed amount if they had never had any relationship with Credit One Bank? Because Credit One Bank sold it to MHC receivables, and then it was sold down this line. So you're going to have to pay attention, pay close attention to your summons, because they will not usually motion for a summary judgment if you have a full affirmative defense based on the documents that they submitted. Because bottom line, they're going to have to overcome the documents that they submitted, because they're submitting those documents as proof on the account. And if you can show them that they're going to have an uphill battle based on the documents that they submitted, you're going to have a better chance of them, number one, not filing for a summary judgment, and then number two, for them to just outright dismiss the case. If you have debt collectors trying to sue you right now, it doesn't matter if it's an original creditor account or a debt collection that they've purchased, please go to my website and inside of live chat, upload your court summons for us to review. And then we'll get back in touch with you to see how we can help you. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab your TransUnion, Equifax, Experian credit reports. If you have debt collectors coming after you early, before it gets to this type of situation, grab my 3-pack of letters, statute of limitations letter. And yes, they are still coming after people for debt that is past the legal statute of limitations to collect. And they do that because people don't know their rights. Grab my cease and desist collection activities letter so you can stop debt collectors by asking them questions that they don't expect you to ask them, and my debt validation letter for the back and forth. That can stop debt collectors before it even gets to this level, because debt collectors have to send you a letter and you have 30 days to respond to that letter. If you don't respond to it, it can get to this situation that you see right here. Thank you for your time. Please subscribe to the channel, post your questions and comments. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.